I request the audience to kindly ensure that your cell phone is in silent mode throughout the session. Thank you. Religion and gender are complex and interconnected aspects of human identity that significantly influence individuals' beliefs, roles, and social experiences. Contemporary societies grapple with reconciling religious teachings and with demand for gender equity, sparking ongoing dialogues and debates. Understanding the intricate relationship between the religion and gender is crucial for promoting inclusivity, challenging stereotypes, and advancing equality in diverse societies worldwide. Ladies and gentlemen, esteemed guests on the dais, and active participants, a very good afternoon to one and all present here. I, Rahul Chivanand Chandu, from 5th year BLLB, deem it a privilege to welcome you all on behalf of KLE Law College, Bengaluru, for the second plenary session based on the theme Religion and Gender. With immense pleasure, I extend a warm welcome to our esteemed panel members from the second plenary session, Dr. Sangeeta Laha, Associate Professor, National University of Study and Research in Law, NUSRL, Ranchi, Jharkhand. I also extend a warm welcome to Ms. Lakshmi Iyengar, Senior Advocate, High Court of Karnataka. I also extend my warm welcome to our beloved Principal, Professor Dr. J.M. Mallikarjunaya, Vice Principal, Dr. Anita N.J. Ma'am, IQAC Coordinator, Dr. Manoj Kumar B. Hiremat sir, distinguished guests on the dais, off the dais, teaching and non-teaching staff, esteemed participants, and students. Now, I request Ms. Zenia Ma'am, Assistant Professor of Law, to introduce our esteemed panel members to the August gathering.
Thank you, Mr. Rahul. I'm extremely elated to extend a warm welcome to Dr. Sangeeta Laha Ma'am, Associate Professor and former Dean of Faculty and Assistant Registrar at National University of Study and Research in Law, Ranchi. I request Ms. Chandralekha to kindly hand over a sapling as a mark of reverence and warm welcome. I'm equally elated to welcome yet another distinguished speaker, Advocate Lakshmi Iyengar, Senior Advocate, High Court of Karnataka. I request Mr. Rahul to hand over a sapling as a mark of reverence and warm welcome. I deem it a privilege to introduce our esteemed speakers. Firstly, Dr. Sangeeta Laha Ma'am, presently Associate Professor, Assistant Registrar, National University of Study and Research in Law, Ranchi. Madam's exemplary academic qualifications include MA in Political Science, MBA, LLM in Hindu Law from Patna University, PhD in Law from the University of Calcutta. Madam was awarded LLB in April 2023 from CNLU, Patna. Her thesis was on democratic decentralization and women's participation, a critical study with reference to Panchayati Raj system in India. Dr. Sangeeta Ma'am has published a book titled Women and Legal Profession in reference to Indian context. Ma'am has previously worked as Director of Research and Training Wing and as well as the Assistant Professor in West Bengal National Juridical Sciences, Kolkata, Chanakya National Law University, Patna, and has worked as a professor and deputy director in Amity Law School, Amity University, Lucknow. Presently, she is guiding PhD scholars aside teaching PhD, PG, and LLB students. 3 scholars have been awarded PhD under her able supervision, while 2 are undergoing PhD currently. Ma'am has chaired and participated in several national and international conferences of repute, has attended faculty development programs, workshops, training programs as a resource person, and has authored several notable research articles. With this, I present Madam Sangeeta Laha to the august gathering. I'd also like to introduce our esteemed guest, Advocate Lakshmi Iyengar ma'am. Advocate Lakshmi Iyengar ma'am is currently designated Senior Advocate of High Court of Karnataka. Madam has 25 years of practice before the High Court of Karnataka and the Supreme Court of India. Madam has appeared in matters before the Enforcement Directorate, National Company Law Tribunal, Karnataka State Administrative Tribunal, Central Administrative Tribunals, among various other notable forums. A few among her notable representations include representing the official liquidator before the Prevention of Money Laundering Appellate Tribunal in Delhi, the rights of the creditors before the Fugitive Economic Offences Court in Mumbai. Ma'am has represented various central governmental bodies such as Provident Fund Department, National Accreditation Board, among several others. Ma'am has been nominated as the state government by the state government as a senior advocate, member of the Academic Council of Karnataka State Law University. Ma'am has graced as a guest speaker at several educational institutions and corporates on matter of law, women's rights, sports, and education. I once again heartily welcome both the esteemed speakers. Thank you, and I request Mr. Rahul to kindly take over.
Thank you, ma'am. Now I request our first speaker from the panel, Dr. Sangeeta Laha, to address the audience.
Thank you. Forgive me, it's a new language I'm trying to learn. Ellarigu namaskara. I learned another two words is Hey Iddira. I'm really honored to be here and a lot of joy that comes because I'm again coming back to Bangalore. I was here in 2014 with the Reliance University before moving to Lucknow. And I was really looking forward for a good session here. And before I start, I must thank the principal, sir, Sharmila ma'am, and my student. Of course, she's a professor here, is Ankita Kapoor. And thank you very much for giving me this opportunity. The topic, as you and I know, is on law, religion, and society, constitutional deliberation on that. I have captioned my lecture as a reflection of multiplicity of matrimonial laws and gender justice in India. How far we have achieved so far. Now, to begin with, we know in the Indian society, we give a lot of importance to marriage because it's a woman's life solely depends upon on this sanctity of marriage, and she's considered to be settled if she is happily married. That's how society look at us. Therefore, she's ready to forego her career, her studies, because she and her parents, the target is the institution of marriage, and nevertheless, we cannot ignore that it is very, very important as a part of her life. Now, every girl and boy looks for that day. And once the day is fixed, so far Hindu marriage is concerned, it's not only a religious sanctity, it's also based on a lot of pomp and show, which is the other side of the marriage. And the pretext and the excuses, it's just a matter of one day. So all the dream comes when the day comes, and for a girl, it's a transformation in her life. Why I say transformation? Because she leaves her parents' natal home and joins her husband for the next phase of her life. So from a carefree, careless girl, she's suddenly, in one fine day, she is thrust with all the responsibilities, and every point of time she's observed. Now, once she comes back from the honeymoon, many a times, even nowadays, her dream is shattered. Either there is no compatibility between the two, or there may be many reasons otherwise. So, from a dream and where she was hankering a week before to get married, now she doesn't, she wants to go out of the relationship. So, marriage from dream, it becomes a broken relationship, and the after effects, the consequences are severe because she doesn't know to fall back. In Indian society, we still do not have all women as independent or economically independent women. And because she doesn't know to fall back, she again goes back. She has to fall back to her parents, where again, in both the sides is from the girl who wanted to get married is now the girl who is looked down, desperate, and doesn't know how to get off the marriage. So the institution of marriage has got a lot of importance. If we are happily married, we have a son, we know we are important to the society. And at some phase of life, even if the relationship doesn't work out, because the woman is not economically independent, she doesn't know what to do. And therefore, she's now a desperate, a dependent, not financially independent woman, and she doesn't know how she would go beyond. So, marriage, so far Hindus are concerned, it's a sacrament. It has got a religious sanctity. And once upon a time, it was taken to be an indissoluble union. But for man, it was not that. In 1955, when the Hindu Marriage Act came into being, the first set of rules that came out, if you read Section 5 of the Hindu Marriage Act, you will come to know, and many of you must be knowing in classes, monogamy was settled. Why monogamy? Because the man could take innumerable women in his life, where the woman could not do so. So for the woman, there was a set of norms fixed for her, and marriage to her, even today, we say it's a sacrament. So sacrament for the woman, but not sacrament feature for the man. And because he was allowed, in fact, at some point of time, if you look back, it was a status symbol. You have 3, 4 wives. The second wife for the pretext of a son. Or the third wife, if both cannot satisfy him. So there were innumerable excuses, but for the woman, she could only, it could be a marriage was a union from birth to death because she could not break apart. So woman at that point of time, or even today, is more in a it's more in an inferior position to compare to man, because she cannot get away. And even if she's get away, the society will stigmatize her. So men all had all the good points of the marriage. For him, it was not a sacrament. For him, it was an enjoyment. And therefore, women had an inferior position. In 1955, we get legislation when monogamy was set a rule, and therefore Section 5 of the Hindu marriage says you cannot have a spouse living at the time of marriage, which means you cannot go in for a second or a third marriage. But when second or third, only if the marriage is performed according to Hindu ceremonies. I'll come to that later on. The Hindu Marriage Act deviated from the earlier norm, brought dissolving the marriage, disability in the marriage, and therefore judicial separation and divorce was introduced, a concept not very well acknowledged at that point of time. A woman who cannot separate out, who doesn't know where to go, what is the point of thinking of divorce and judicial separation? But less legislatures that point of time, it was a revolutionary step. And where suffocation of relationship is there, it is better to be apart. So how to be apart was going through the court. So therefore, judicial separation and divorce was introduced. But Hindu Marriage Act retained the sacramental structure. Why I say sacramental structure? To have a valid marriage, one has to go through all the proper ceremonies that has been written down in our scriptures. So the element of Homa has to be there, the element of Kanyadan has to be there, the element of Panigrahi has to be there, and most famous is the element of Saptapadi has to be there. If all these four ingredients are there, then only marriage is said to be complete, otherwise it is not a valid marriage. So, Hindu Marriage Act retained the sacramental part. But as I told you, sacrament on the point, because the woman becomes now Pati Vrata, she has to follow what her husband commands. And therefore, when she leaves her natal home and joins the husband family, despite the husband being independent, economically independent, and the society does not allow him to have a separate residence because he has got a second woman now, the wife in her home, he is allowed to stay in his home. He has all the freedom, but this woman loses her independence even to the extent of clothes. So the carefree life now is full of responsibilities. And once she's not being able to display the responsibilities, she's not only accused, but to some extent, her mother is also, in some examples, in certain cases, her mother is also said that she has not trained her daughter how to go along with the husband's family, as if we should maintain that. The society tells us to maintain that, but so far husband is concerned, he doesn't change his way of life because he is in the same parents' home or his home, so he is a master of home, and the wife has not only to serve and make him happy, but also his parents and relatives, kith and kin, who are in that house to make happy. Failing which, the consequences are great. So the sacramental feature has tilted towards the woman, but not towards the man. Because not only her surname, everything starts changing. Now, if that woman doesn't, society are very fond of, excuse me for saying that, but society is very fond of having a son. And there are reasons because there is a perception that son will take care of me when I'm old, or he will do his pious obligation when I die. So there's always a craving to have a son. Also, the property will go to him. Daughters, all of us know how struggle we had even to get our own property. I'm not going into that now for the paucity of time. So the craving of son was always there to carry on the family lineage. And therefore, that gave again a pretext to the so-called husband to marry again. Because sometimes the first wife also consented, gave the consent that yes, he can go for the second marriage because she's unable to give the birth of a son, as if the genealogy of the children is only biologically she is fit. There is an XY chromosome where the husband also has an equal role to play, but the society stigmatizes her that you cannot bear a son, and therefore the husband gets again an upper hand to go for the second marriage or to go for a relationship. Now, because monogamy was set a rule, the second relationship, if not married, if it's not legally married, in other terms we say he has kept a concubine or a mistress. So one step before is, what he does is, he adopts a Gandharva form of marriage. So first marriage is with lot of pomp and show, so much of money is exhibited, but in the second time when he goes for the marriage, it's always a hush-hush affair. And what they do is the exchange of garland. So with monogamy, there is also provision of bigamy. That was also introduced by the Hindu Marriage Act. Now, before I go into the bigamous marriages or bigamy marriages, because marriage is a social institution, it is a recognized institution, it has got a lot of importance. What we conclude, number one, marriage is considered to be a rule in our society. So being single, you are outnumbered, you are an exception. You're not allowed to be single. But because there has been so much of suffocation in certain relationships, nowadays, many of us prefer to be single. After all, एक रात का शादी इतना pomp and show हुआ, there's so much of pomp and show, and next day, or after a week, or after a month, maybe after a year, because you don't want to come out, is the whole show goes useless. So the other reaction of some of the society is, let us not go into the norms, let me prefer to be single. But single is still an exception in our society. Two, alternatives to marriage are non-existent despite the recent judicial pronouncement decriminalizing live-in relationship. We still do not accept in our society live-in relationship. How much modern we become. There are in the metro such relationship is coming on, but if you go to the smaller towns and the villages, such a relationship is not well accepted. Third, getting out of marriage is also difficult. Getting is, especially in arranged marriages, is equally difficult for the parents, but getting out of marriage is very difficult because nobody wants to go to the court of law, and all of you know how much of time taking it is. So it's equally difficult, and the grounds have been specified. So you have to establish that ground. The lady who's coming to a new home, she has to establish, yes, these are the grounds mentioned in section 13 of the Hindu Marriage Act. And not only to establish, it also has the judicial, the facts has to be established, judicially established, and only after the courts evaluate those facts, then only she gets relief, and it's a very difficult proposition. We also, from the importance of the institution of marriage, we also feel that that men are economically active, and women's role is very confined to home. You are only supposed to take care of your home. If you go beyond that rekha, if you go beyond that, either you are said you don't perform well in your home because you are all the time out, and many of the working women would accept with me, or you're condemned. If the baby cries, the mother at fault, but if the baby is good, the credit goes to the parents. So society tells you your first priority is your home. So some of the brilliant students who do get married, they have to forego your career because that is the demand of the society. That is the demand of the in-laws. That is the demand of the better half of mine. So she forgoes her careers, she keeps the degree right in the, yeah, and you are supposed to do the household norms as a good homemaker. Though you're capable of earning and inheriting property, but those decisions are also of the men's domain. And lastly, a very important part referring to the theme of this plenary session is the Constitution of India inculcates the concept of gender equality and also says that the law which is inconsistent with the constitutional principles, no law which are inconsistent with the constitutional principles can be valid. However, the question is, when there is so much of gender equality in family laws, whether family laws are the laws within the meaning of Article 13 of the Constitution or not, is itself a subject of debate even today. And why I say so, before going into the binary, if you take the Goa, Daman and Diu laws, the marriage is actually based, for the Christians in Goa, Daman and Diu, which is performed in the church. There also you will find the male is a dominant role to play. The Hindus of Goa, because they are domiciled in that area, they are not governed by the Hindu Marriage Act. Same case with the scheduled tribe also. They are not governed by the Hindu Marriage Act. But whatever the reasons are, whether the Hindu law applies to them or not applies to them, the dominant role of the male family sphere always prevail and women are subjugated to it. Now, let us come to what Kautilya Arthashastra had said, because we retain the sacramental part of the Hindu marriage. It says, Amoksha Dharma Vivahanam, that is the Hindu dharmic marriage, is an inviolate, inviolable, indissoluble, interminable, external and perpetual union. So Hindu Marriage Act introduced radical changes, introducing judicial separation and divorce, but at the same time retain the sacramental part, because without which the marriage is not said to be valid. Now, today in our society, as I told you, we must have home, we must have kanyadan, we must have panigrahi, we must have saptapati. Do you think in an educated society of ours, what does the word kanyadan means? You're gifting your daughter, kanya, to the husband. So she moves from the right to the left. Do you think we daughters are something to be gifted? So why has that Hindu law retained the interpretation of kanyadan when it violates my basic human dignity? I'm not a person to be gifted to someone. I have a flesh, I have a blood, I have a feeling. Whom do you get? You can give jewelry, you can give, earlier it was cows and all. We had 8 forms of marriage, of which cow used to be gifted. So many things could be gifted. Why Kanya has to be gifted? Because for a minor girl, they're fixing the age. But the minor boy, you're not fixing the age, because he has to have that brahmacharya ashrama. He has to go in the pathshala or the Gurukul system. So 14 was a marriage or 15 was a marriage kept for the girl. But you have not kept 15 or something like that for the boy. When does the boy is entitled to get married? Once he is independent, economically independent, then he comes for the marriage. For the girl, you have not set such norms. Therefore, Kanyadan is still, to many of the to many of the legal philosophers, should not be attained. There can be another substitute for the word Kanyadan. So that is what I have objections to it. And not only that, it has been eulogized by the Honorable Courts of India. And they say that when a man is performing the second marriage, it should be validly performed. Otherwise, that element of bigamy is not attracted. 493 and 494 of the IPC. To bring, the Hindu Marriage Act has brought bigamy as a punishable offense. So at best, what the wife can do, she can go for a divorce. But if you want to bring that husband under the bars, she has to prove that the second marriage was also validly performed. So for 2 women, the marriage has to be validly performed. For the guy, he brushes his shoulders. He says, the first marriage was a void one. So she is not my first legal wife. The second marriage, he doesn't want to be in the garb of coming to attract that section. He doesn't want to be punished. He says that the first marriage is a void one, or he says that the second marriage is a void one. So if a second marriage is a void one, you cannot punish that man under the garb of bigamy. So one side you're talking of monogamy for the woman, but on the second side, the man is giving liberty to the man to even perform the second marriage. And then there has been judicial pronouncement repeatedly that you cannot convict a person until and unless the second marriage is proved. Later on, in Lily Thomas' case, the factum of converting for a mala fide intention was taken up. So many a times the man from Hindu either converts to Muslim to marry for the second time, or is a Muslim, converts to Hinduism and marries for the second time. So under Hindu law, both the marriage has to be under Hindu Marriage Act, or it has to be validly performed. If he performs the second marriage in some other form, you cannot convict the man. So at any cost, you are not penalizing the person who has committed a crime. I wonder when such provisions would change. So the same for polygamy, we established monogamy in Hindu law, but polygamy is still prevalent. So far Muslim law is concerned, though it is in a restricted sense, counter to that, the Muslim woman cannot have more than one husband, but for the Muslim man, it is restricted up to four. The fifth marriage for the Sunnites, it becomes an irregular marriage, but if it's a Shia Muslim, he can perform the marriage in a muta form. So there has been discrepancies in many forms. For the Parsi, if the marriage is a contract, it's only with two witnesses and a ceremony known as Ashirvad is performed. So with multilingual, multifarious population we have in India, there are a multiplicity of matrimonial laws. Until today, we talk of Article 14 and 16, we talk of equality before law, but I doubt that whatever changes have come in the Hindu Marriage Act, before, after amendment also, we had a lot of amendments also, I doubt we have really practically achieved what the objective was set in the Hindu Marriage Act. Thank you for being patient. Thank you.
Thank you, ma'am, for your valuable insights. Now I request our second speaker from the panel, Ms. Lakshmi Iyengar, to address the audience.
Very good afternoon to the August gathering here. It is, after all, the month of August, isn't it? I think all of you have had a lot of busy bella and curd rice, because I have seen tons of you taking a quick nap out here. I had warned the college when they invited me for the second session. I said, I don't think anybody's actually going to listen to me because it's post-lunch session and nobody's really going to want to listen to the entire speech. I don't know how much, if all of you are aware, I'm told that a lot of judges do not eat rice during their afternoon meal because they'll be fast asleep during the second session. So I think a lot of judges try to keep their meal very minimal and ensure that it's non-rice based so that they have an attentive audience. Let me get straight to the issue. I think the topic today is religion and gender. As a senior advocate, it is my duty to speak to all the law students, specifically law-related issues wherein we cover both these aspects. With Dr. Sangeeta having provided such insights, it's imperative that I focus on the process of how our country, through the courts, have attempted to narrow the vast and wide gender discrimination over the years. More specifically, the role of courts within the ambit of our constitution, several acts and laws, carefully adjudicating sensitive issues so as to prevent the misuse of religion as an excuse to deprive women of their rights. Juxtaposing the words gender and religion results in an explosion of sorts. What is beyond comprehension is that the feminine gender is alone the victim when society chooses to stamp its authority on interpretation of religion and religious practices. When Dr. Sangeeta was speaking, it crossed my mind that I would actually want to put forth to you. It isn't a complaint, it is just a suggestion. What went through our minds is that I looked at the invites. Women are always invited where gender is an issue, where you speak about women's roles. You don't find women invited in any other topic. What I also noticed was whether you have your function where you've invited certain persons or you have tomorrow's function. I don't see any lady judge there. I don't see any other lady senior advocate there. I don't see any other lady advocate having been invited to speak on any other topic besides gender. And it isn't a complaint, it is something that is imbibed into us. And I'm sure a lot of you lady professors would not have even realized it because we have accepted it all along. And it is just something that crossed my mind. We have so many lady judges here, but none of them were thought about. And I think all of you as law students will realize that quite often when you go and think about approaching a lady advocate, you'd always think, oh, she must be dealing with family court matters. It's never there in their mind that a lady advocate could go beyond family court matters and actually deal with intellectual issues. This is something that I think we have to go beyond all of these stereotypes and sometimes making an effort to realize that we need to make an attempt to bring about changes. If you see a lot of serials, most of the serials that we watch, all American and UK based, you'll see tons of black cops. You will see a lot of women detectives. You'd see an amalgamation of both whites and blacks going out for a drink, socializing, which in general you don't otherwise find. The reason these are made this way is for us to change our perspective. Therefore, in the same way, if we slowly change our perspective by bringing in women in all other facets of life, and we have them, in fact, I had a conversation even just yesterday when we were discussing about choosing of persons. I will not talk about in what fora. I said it shouldn't be about gender. You should just look at the quality of the person and pick them irrespective of whether they're a male or a female. So that's when this man told me, no, we need to specifically pick women. Not that most of the men are very good. You'd only find 20% of them who actually qualify for that, but nobody comments on it. So it's all right to pick women, irrespective of whether you think they are good enough for that post or not, only because you have to motivate the next generation when they see that many women there and say, all right, it is possible for me to get there. And I thought, okay, I mean, men seem to think quite progressive too. I'll come straight to the topic now. This is basically, I have noticed in most contracts, time is the essence of the contract, if you've all seen. So time is the essence of my speech. 5 minutes is done. So all I have is left is 25 minutes. And therefore, I'll cut to the chase and I'll go into the several facets of law that have redefined equality. Starting from the preamble of the Constitution, it resolves to secure justice, liberty, equality, and dignity for all. The reason why I, in fact, wanted them to put up a PPT is while I speak, it is important that you realize what our preambles tells us. And then it's important for you to connect on the topic of religion and gender. So our preamble basically gives us equality and dignity. When I speak of equality, what do I mean? Both men and women should be termed equal, and that isn't there. Article 14, what does Article 14 provide for? It provides for equal treatment of every individual. Article 15 provides for, it prohibits discrimination based on religion, race, caste, sex, place of birth. Therefore, the Constitution, besides the preamble, has given us 14, 15, which protects us straight away. Yet at every phase of life, we have to keep fighting for those rights. Despite such a strong backing in the constitutional provisions, portions of an irrational society constantly take refuge under Article 25 and 26 of the Constitution to deny and deprive women of their rights. Now, if you look at Article 25, what does it give you? It says freedom of conscience and free profession, practice, propagation of religion. Subject to, that is what is important. Subject to, it says subject to public order, morality, health, and other provisions of this part, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate. So everything ultimately has a clause, and that is what you need to look into. The cases that I would probably just focus on are on several areas. One would be divorce, one would be marriage, one is maintenance, one is guardianship, and finally I'll come around to the latest judgments that have dealt with all of this. Under Christian law, before 2001 amendment in the Divorce Act, for a woman to seek a divorce on the grounds of adultery, it was insufficient until she also included cruelty as a ground for divorce. However, in 2001, this was amended and both men and women could be given the right to seek divorce on the grounds of adultery alone. These are changes that are brought about keeping in view the changes that require to be made in our laws. Under Muslim law, adultery is not recognized as a ground for divorce unless it is committed with women of evil repute or leads to an infamous life, which is included under cruelty. In the Sharia Banu case, all of you have already studied under judgment in 2017. Her husband divorced her by pronouncing the words talaq 3 times, which is known as talaq ibad or the triple talaq. Now, Banu filed a petition before the Supreme Court in 2016, challenged the constitutionality, the polygamy, the nikah halala. So the 5-bench constitutional judgment had struck down the talaq ibad, and the instant divorce given by Muslim men through pronouncement of triple talaq in one sitting as unconstitutional. But the issue of polygamy, all of that still remains. Now, the other judgment, which is very important, which is the Shah Bano Begum judgment in 1985. The reason why this was critical and brought about an immense change in our society was the interpretation. Supreme Court granted the maintenance to a divorced Muslim woman, irrespective of what Muslim personal law says. Supreme Court held that Section 125 of CRPC is also applicable on Muslims. It also concluded that CRP is a secular law and there's no conflict between the provisions of 125 and those of the Muslim personal law on the question of Muslim husband's obligation to provide maintenance for a divorced wife who is unable to maintain herself. So what happened if a man left a woman and went on to marry somebody else? She was left with nothing. Since she was not given education, she couldn't stand on her own feet. What does she do? Therefore, the court stepped in, and under Section 125, they interpreted it that you could always seek maintenance in this, and therefore, whether personal laws gave you the freedom to seek maintenance or not, the Criminal Procedure Code gave you that liberty to move the courts. The nikah halala is a process where a divorced Muslim woman has to first marry another person, consummate it, and get a divorce from a second husband if the couple were to remarry after a compromise. So Ashwini Upadhyay, one of the usual PIL petitioners, he moved the Supreme Court seeking a direction to declare polygamy and nikah halala unconstitutional and illegal. The aspect still remains before the Supreme Court that has to be decided. The khula is a form of divorce initiated by a wife in Islam, which is recognized in personal laws. In 1939, an act was passed to secure the rights of Muslim women, the Dissolution of Muslim Marriage Act in 1939. If you realize that there was transformation in our society very early, even prior to independence. It was passed to provide various grounds to enable Muslim women to divorce a husband. Women generally faced with many difficulties in their matrimonial relationships for which they had no remedy. To solve these problems, the Act of 1939 enabled them to seek divorce. Now, the case law, if it's specifically Mohammed Rafi versus State of Tamil Nadu in 2023, khula, which is recognized under personal laws, is now statutorily recognized under the provisions of Dissolution of Marriages Act. Now, the Supreme Court said that the courts are empowered under Section 1 of the Family Courts Act, read with Section 2. And they felt that these private bodies, as Shariat Council, cannot pronounce or certify dissolution of khula. So it was held to be open for a Muslim woman to exercise her rights before the family court. In Hindu system, There was one judgment that stuck its neck out, and this was a judgment in Sharma versus Sharma, domestic and intimate partner violence and gender discrimination. Here, this a lady who was unmarried, she left her job and entered into a live-in relationship with Sharma for a period of about 18 years. And he abandoned her in a state where she was unable to maintain herself. She couldn't work either. She moved under the Domestic Violence Act. Now, all of you must be wondering, she's not a wife. How could she move under the Domestic Violence Act? Supreme Court here, the High Court had ordered, the Domestic Violence Court had ordered maintenance of about 18,000 rupees to her. The High Court stepped in and said she's not entitled to it in view of the fact that she was aware of his earlier marriage. Therefore, if you are aware of his earlier marriage and get into a relationship with him, you're not entitled to. Supreme Court upheld the view of the High Court, however, gave liberty in other matters wherein if the live-in partner was unaware or was misled by the man into getting into a live-in relationship wherein he had not revealed that he was already married, then she would be protected. She could move under the Domestic Violence Act and she would be entitled to maintenance. This again was revolutionary in our system and society wherein live-in relationships are not really looked into. I've discussed divorce, I've discussed maintenance with respect to even live-in relationships. When we come to guardianship, all of you are aware there's something called the GNWC, that's the Guardians and Wards Act. What happened earlier was women were not naturally the legal guardian or not a natural guardian recognized under law. So the Geeta Hariharan case in 1999, it held that both the father and the mother are legal guardians of a minor Hindu child, and the mother cannot be said to be natural guardian only after the death of the father, as that would not only be discriminatory but also against the welfare of the child, which is the legislative intent of the Hindu Marriage and Guardianship Act. The case is important because it established for the first time that the natural guardian referred to in the Hindu Marriage and Guardianship Act can be a father or a mother, whoever is capable and available to take care of the child and is deeply interested in the welfare of the child. Under Muslim law, the mother is entitled to the custody of male child until the child reaches 7 years of age, and under the Sunni school of law, it's about 2 years. In Shia also, it's clear that Mohammedan law, the mother is entitled to custody of a minor child only up to a certain age where the child is an infant, where the child requires the mother. On the other hand, the father alone is the natural guardian. Only if the case of the father is dead, the executor is the legal guardian according to Sunni law. What happened with respect to this is that court stepped in and refused to accept the personal loss of a person. The court stepped in and said the importance should be given to the child. It was of paramount importance that the child should be considered overlooking personal laws. Therefore, under the Hindu system, they had to amend the laws. Under the Muslim system, the court stepped in and said, in each case, we will look at who is a better parent and where the children would have to be. So, personally, I dealt with a matter where both the sons had crossed 7 years, and therefore the father filed an application, who was also a lawyer, by the way. He filed an application stating that both are above 7 years of age and therefore they should be with me. The court stepped in and said, the children clearly need their mother. At this point of time, you were not entitled to it. This was at the time of interim custody. The court denied him interim custody and in finality also held that the mother was a better parent. Therefore, the courts are able to overlook religious sentiments and the religious, the followings of all times for them to step in and say what is actually important. Under Section 25, under the Guardians and Wards Act, the Madras High Court also had held that the interest of the child is of paramount consideration and minors' welfare should be considered And therefore, in the case of Mohammed Gauss Mohiddin, the Kerala High Court had said that, the Chennai High Court had said that the mother would have custody of the child. In terms of succession, we've seen several changes in our system. Women earlier were not entitled to at all. In Christianity, Mary Roy's the case with respect to Mary Roy versus Kerala, women from the Syrian Christian community in Kerala were prevented from inheriting property due to patriarchal traditions. Of course, you know that in Kerala, the Nair community, of course, is a matriarchal form of society. What was one of the most progressive forms of society, unfortunately, even in the Nair community, the men have started taking food. So it shifted from a matriarchal system to a patriarchal system. Whereas here in the Syrian Christian community, patriarchal system was followed and women were not given rights and property. And in 1956, Supreme Court delivered a landmark judgment that granted Syrian Christians women the right to seek equal share of their father's property. Under Hindus, of course, all of you would be well aware of the latest judgments. The latest one in 2023, the Kamala Neti case, Supreme Court observed that it is unfair to deny tribal women right to equal share in father's property when the same right is available to non-tribal women under the Hindu Succession Act. Therefore, tribal women again under their specific tribes have different forms that they still follow. They could still follow all of that, but the court step in when they think that it is discriminatory. In Vinita Sharma versus Rakesh Sharma in 2020, Supreme Court ruled that the woman or the daughter shall also be considered as a joint legal heir as a son and can inherit ancestral property equally as a male heir, irrespective of the fact that the father was not alive before the Hindu Succession Amendment Act. Muslims, of course, nearly 3 decades after a Muslim couple from Kasargod, of course, had moved to the courts recently because they had to remarry just to ensure that their daughters were not losing out their properties. So they went and registered it before the sub-registrar under the Special Marriage Act, and that was held that it was incorrect since they had already divorced. They had to again remarry, consummate, again the divorce, and then get back together. That again is right now under a decision before the courts. I did see a couple of articles written by all of you. Some of you have dealt with the Sabarimala case. Now, the Sabarimala case was extremely important because it dealt with a lot of sentiments, Hindu sentiments. What the courts had to look into was not the sentiments. The courts had to look into whether this exclusionary practice, which is based upon the biological factor exclusive to female gender, amounts to discrimination and violates the very core of Article 14, 15, and 17, and whether it is not protected under Article 25 and 26. All of you have your views. I did read, I think that was Vishal or Vishwas, I think, had written that article. I did think that it was finally very it was very apolitical. He did seem to think that everybody is entitled to our personal views. Yes, we all are, but ultimately law will have to step in. Under the Sabarimala, the judgment of all of you realize there was the arguments were based on the fact the Lord was ultimately in his brahmachari form, he was in a meditative form, and therefore he could not be, disturbed. My view was the devotees are not mandakinis over there trying to disturb his penance. A devotee cannot have a gender. You cannot be looked at as whether it is the man is not going to disturb him or the woman is going to disturb him. The women ultimately go there as bhakts. And if they were left out due to a biological reason, that was ultimately, it dated back to a system and a time where it was a question of hygiene, which is not an issue at this point of time. It was also with respect to whether exclusionary practice was permissible or not. And therefore, despite the fact that a lady judge had held that it was left to the religious factions to decide, ultimately that was not the case. With respect to female genital mutilation, also I read an article and I thought it was well said. With respect to the sati system, ultimately we'll have to come down to this. If you look at the sati system, there was a lot of persons had refused to permit their women to stay away from the pyre. They were forced to get into the pyre and immolate themselves. I think it was the Roop Kanwar case that changed and transformed with the Supreme Court stepping in. What most of us don't realize is in mid-1800s, Raja Ram Mohan Roy had brought about a complete transformation. He convinced the British to pass an act at that point of time to prevent sati immolation that nobody is aware of. Raja Ram Mohan Roy in mid-1800s had brought about a change in society stating that there should be no child marriage, there should be no polygamy, there should be no sati, and this was done and in sometime around 1880s. By that time, he had already achieved a transformation in society. Yet, we are still trying to bring in acts and changes in society. The last would be the hijab case. All of us have had our individual opinions. I think it is up to the Muslim woman to decide whether she would want to wear the hijab or not. How could the court step in? All of this was ultimately, it was a case of institutions. Whether educational institutions would have the right to decide as to what one must wear. Yes, we are all entitled to wear what we would like. That would be in the confines of our home or in general public. When we enter a certain place, which is an educational institution, whether it is the Ghungat system followed by the Marwaris in the Hindu community, or whether it is the hijab followed by the Muslims in Muslim community, they are entitled to follow whatever they want. But in an educational institution, you have the right to set an example by stating all of us are equal. We will not discriminate. We will not have any difference in terms of what you wear. You have a uniform. That's the way to bring about changes. Just the way the sati system always refused to bring about a change, and you had to bring it out by way of law. For women to progress in society, men are not going to permit it. Because religion is always their backing, which they go back to stating, I'm sorry, but my religion does not permit it. And therefore, until and unless the courts step in, the change in society will not take place. I think I have almost concluded my 25 minutes to 30 minutes of this case, and therefore I would just want to conclude by stating that progress, not regress, that is need of the hour. Thank you so much for your time.
Thank you, ma'am, for your thought-provoking address on the intricacies of various legal questions. Here we come to the end of our second plenary session for the day. I now request Chandralekha from third year BA LLB to propose the vote of thanks.
Ladies and gentlemen, distinguished guests and esteemed participants, on behalf of the organizing committee, I extend our heartfelt gratitude to all of you for joining us at this remarkable, insightful session on the theme, religion and gender. Your presence and active engagement have contributed immensely to its success. We would like to express our sincere gratitude to our esteemed speakers, Dr. Sangeeta Laha, Associate Professor, National University of Study and Research in Law, Ranchi, Jharkhand. I request Ms. Zeena Ma'am, Assistant Professor, to kindly present a memento as a token of our sincere gratitude. I would also like to express our sincere gratitude to Ms. Lakshmi Iyengar, Senior Advocate, High Court of Karnataka. I request Ms. Zeena Ma'am to present the memento. Thank you, ma'am. I extend my heartfelt gratitude to our beloved Principal Sir, Dr. J. M. Mallikarjunaya, Vice Principal Dr. Anita M.J., and IQAC Coordinator Dr. Manoj Kumar P. Gunawar, Faculty Coordinator for the second plenary session, Ms. Zenia Ma'am, distinguished guests on the dais and off the dais, teaching and non-teaching staff, esteemed participants, and students for their active involvement. Thank you all once again for being part of the second plenary session of the National Conference. Your